Okay, competent to contract. Open question to all. Who can contract and who cannot contract? What is in your mind? In my previous training, I took this.
Who can, what's up?
Everybody can contract. Who cannot?
Minors.
Great. Who else?
Mind with conscious mind.
He cannot do the contract. If you are, there are various category of mentally disabled, unsound mind, like lunatic, madman. So there is some thin line in that.
Unstable state of mind.
Then if somebody who's in a mental situation, he goes to a mental asylum or hospital, they ask him to sign the contract. And that time he's in full conscious. He signs it. Is it valid or void?
That time it is valid, but
That time means for 2 hours the agreement is valid. Agreement is valid or void?
like what I
No, actually-
No.
For this medical is valid since he's signing in the mental hospital in the presence of doctor. वो कह रहा है ना कि अभी conscious है इस mental लो we can sign.
Repeat. Last line.
जो doctor hospital में sign कर दिया. The doctor is saying this person is conscious now. अभी sign कर सकते.
Opposite to that, he is drunk and he signs a contract. Valid or void? Because he's not mental. He's signing a contract in the drunken state.
Intoxication पर अच्छा हो.
नहीं मैं
It is not valid.
It's different. I'm saying again, unsound mind
say it is
right now, and he signs.
It's not valid.
Why?
Because
He's
it's not
a
an
person of
stable mind, state of mind.
Great. So based on your response, we can sum up that the present state of person when he's signing the agreement is important.
Yes.
A normal person in intoxication makes a void agreement, but a mentally unstable person in a present correct state of mind makes a valid contract. All medical consent are those only. Somebody is defected, somebody is like under treatment, somebody is not mentally stable, they are under exertion. Still, they are very much aware that they are signing a consent for operation. That is a valid contract. Okay. So minor, unsound mind. Who else? Person not allowed as per law. Court makes a sanction. You cannot go abroad. Okay, as a law. Now you purchase a ticket, air ticket. That is a contract. So are you allowed to do that contract? You are by law, you are. So 3 major grounds. Minority, we'll take a case and then I'll ask you questions.
Minority, what does the here minority signifying?
Below 18.
Below, no, it depends. No, it's not that. It's not general. In Indian law, because there is a personal law also, Muslim personal law is there, minority is governed with Indian Majority Act. It says for all, what is the general age? We cannot straight away say it's 18. Somewhere it say for these X person above 16 can do it. So as per Indian Majority Act, 1872 or 5, I don't remember. As per that, the minority and majority is decided. Like in Muslim law, the marriage is allowed before 18 because it's a personal. So we cannot say straight away 18. We have to say that as per that relevant legislation or jurisdiction or the law to which the person subjects, what is the age of majority? Then you will be a major. You cannot be. Being a minor, you cannot do, but a minor can receive the property from a dying person.
So all in all.
Based on certain condition as per
all in
law
all,
of property.
It includes the age, huh?
Hmm?
Age.
Age, obviously age. Majority minority is governed with the age. Now, competent to contract, first thing is the person should be major, not minor. It's not 18, 19, 16, major, not minor. Whatever the Majority Act says, as per that, that person to whom class or social group he belongs to, he should be major. Let's see. Second is sound mind, we just discussed. Person or party not qualified from contracting as per the law. These are the 3 grounds as per section 10 of Indian Contracts Act. This is relevant to you because you should know that if some person is in prison, he cannot make a contract with you. If the subcontractor signs 14 years old child with a POA, you should not sign. That is the relevance. That's why I'm telling you all this. You should know what the law says. Saudi Arabia, I don't know. Again, there may be a law here because I'm telling you with respect to Indian law and Indian contract. You need to see that. Yeah.
Suppose the person is not related, but temporarily deputed on the particular job. No, he cannot execute.
If he see he is on temporary deputation, his management will not give him POA. POA is given to permanent employee with the credentials, with the seniority, with the exposure, with the confidence that will be the part. They will not give like a POA to any T-boy, right? Or the person who's leaving the organization. And also, good question here, that the POA is subject to the position also. Company's approval schedule say that the person submit offer should be a general manager, not less than that. So I am the general manager. So PO is given to me. Tomorrow I use my authority to sign it, not my personality that Lokesh Pathak will sign it. Tomorrow if I go, another person comes as general manager, he becomes responsible for that customer, because it's position and the person.
Same motion is somebody that is not related to public.
He should not be given POA. He is not authorized. Yeah. Now, there's a case. I'll give you the facts of this case. It is a very old case, around more than 100 years ago. And then you have to tell that what should be the result. It is related to minority milestone case in Indian jurisdiction. There, the case name is Dharmodas versus Mohari Bibi. It is 1893 case. I'll give you the facts of this case now, and then you tell what should be the judgment by the judge. There was a landlord. His name was Dhamrodat. There was a boy, which is minor. His name is Dharmodas. He goes to him and he says that I want to sell my land. And these are the papers. He was a minor. He was not allowed to contract. He took that. He gives him amount that time, big amount that time, and he take the papers from him and keeps in his custody. Now, is it a valid contract? No. Why?
Because whether he signed in his name, then it's valid.
Property may be given to a minor, I just said, as per the Property Act. But for that, he should make a contract to sell or transfer. He cannot make a contract. He can just keep, it will be in a deactivated state until he becomes major and allowed to make a transaction on that property. That says property. So here, it is a void contract, void ab initio, void since starting. Direction in favor of, decision in favor of minor in 1895, because when his mother came to know this boy, he gone to him, that Dharmodas, that this is a void contract. I don't mind it as a contract. You give the property papers to me. He told no. They both go to litigation. So this case was the daughter of that Dhamrodar, and this Dharmodas was the boy. So they both gone into litigation and decision was given in favor of minor. So minor, property is yours. Money is with minor. Money is not given back here as of now.
No, sir.
Wait. Here, the point was, the dispute was my property or his property. Court said his property. Khalas. Then what happened next? I am telling you because there was a dual impact. So the decision was in favor of minor. Property was his. Possession returned. Now his daughter, Mohari Bibi, she made an appeal after almost 10 years. That okay, the property you gave him, now give my father's money back to me. Then the court decided what it might have decided. Decision upheld, no return of money, because you paid based on a contract which was never a contract. Had it been a valid and then void, you might have got some chances. But this is like throwing your money in a well. Because the contract from day one was void ab initio. It was with the minor. When there is no contract, you just give the money. On what grounds in contract you will be given the money? No. So this was a dual impact. So you should always refrain from making any contract with a minor. The law supports minors, women, and old aged. No dispute with these three persons. Otherwise, there is a prejudice in the society that they are weaker is innocent. You drive a car, somebody comes, his mistake. He comes in front of you. There's a prejudice in society that the person who's richer, the person who's more resourceful is at fault.
Delhi rape case also,
Yes,
they
yes.
have released that minors
Minors, yes, that it was decided. Then there is some breakthrough in this. This is because of the contracting, but now the law says that they made some changes in this.
Yes, yes.
Also,
After that,
no,
this minor.
after that, they have
Yeah,
changed the
but in contract law not. That was a crime. That was
That is
CRPC.
the crime,
This is contract law. This is as it is.
So no return of money paid to minor.
Yes.
Yeah.
Damodar
Paid
Das
to or
will
paid
not
by?
pay money.
Yeah, paid by minor. Okay. Now, sound mind, section 12. Capable of understanding and making a judgment. This is the definition. If a person is capable of understanding and judging, he is person of sound. Okay. Not intoxicated or under the influence of drugs. Mental capacity at the time of signing is important. We discussed. Okay. Sound, but occasionally unsound at the time of contracting, incompetent to contract, like intoxicated person or any person who sound, but at that time he was not in his state of mind. No contract. Unsound, but occasionally sound at the time of contracting means competent to contract. He can contract. Okay, essentials of a valid contract. Person, party not disqualified from contracting as per the law. This was the third point we discussed. Right?
Sound mind, what was the last one?
Unsound, but occasionally sound at the time.
Both conditions, unsound, but occasionally sound. He is competent to contract. The person who's not mentally okay, but he signs his consent for the operation because at that time he's in a state of mind. That example I give. So your immediate state of mind is important, irrespective of your permanent position. Essential of a valid contract, free consent, we just discussed. When you say the consent is free, he gave his consent, he gave his consent. His is free consent, his is not free consent. What free, not free? When you say consent is free.
Does not.
They don't have any obligation.
What means when you are not objecting?
Consent is not objecting only. Consent is consent. I'm saying what free consent is. And what is consent? Well, how free consent
Free
is?
consent means you are not allowing by saying, okay, it is allowed, but you are not restricting, saying it is not allowed also.
This is a laptop. You have to pay 100 riyals for this. You came, you liked it, you paid 100 riyals and came back. Now I go to you. I take out the revolver. Buy it at 100, otherwise I'll kill you. Again, you take it. You will pay and take it. Both consent.
And so
This
it's
is free consent now.
No, this is not free consent. The first was free consent.
now, sir, if you tell him that you don't buy it at 100, make it 80, you get him in this. So this is
That is
also,
negotiation. That is not.
it is not.
No. We are talking about the criminal things, the civil offenses. So free consent is which is free from
Any conditions, any.
condition. It can have conditions.
अच्छा, कट्टा में चरखी है तो इधर बुला लो.
क्या है? What is it?
सही है, sir.
Question.
Forced.
My uncle is a chief minister. Purchase it, otherwise I will see. Undue influence. So what are those words? Big words in law. Question. Section 15. Amkana. Question. If somebody consents to a contract with a question, he proves that it was under question. Gone. Contract is void. Committing or threatening to commit any act forbidden by Indian Penal Code Section 45 of 1860. Whatever comes in that category, if you are committing that act to sign a contract, that becomes question, and that agreement is void. Unlawful detaining or threatening to detain any property. I'll kidnap. I'll abduct. Either do or just say. Threaten also. Because you are influencing that person to give his consent. To the prejudice of a person for entering into agreement. So this is all hanky-panky you do for entering into the agreement, and which has coercion, it's gone. It's no more a free consent. It's not a free consent because free consent not caused by coercion. First thing. Okay. It should be missing. Then it's free. Undue influence. I just said. My uncle is a minister. If you don't do, I'll see that I can do. Okay, get it. Consent is there. Agreement is there, but that is void. Because you have to prove that it is because of that undue influence he mounted on me. Use of power, position, or authority to gain unfair advantage in the agreement. Third condition is fraud. Free consent should be free from coercion, free from undue influence, and free from fraud. What is fraud?
Free for fun letters.
Example. I'm saying what it is. Okay, this is one example. This is fraud.
झूठ बोल के कुछ कर दिया.
Then what is misrepresentation? दोनों same है. Both are same.
It's not legal.
Both are legal. You can do misrepresentation.
Like
Client writes to you, you misrepresent it. If it is not legal, why he is writing?
so you are selling one electronics item, stamp it like it
Things
is
not belongs to
not
me.
actually.
You guys are giving me example. Fine. What is the difference? When I say you did, you lied. When I say you did fraud, when I say you did misrepresentation. Tell me.
So, fraud is something,
Janbuj
on which
ke
we
kiya
have
hua.
agreed.
Repeat.
Means
Willingly,
willingly
You are doing something.
Wrong, knowingly, impactful, innocently. मुझे कहा गया, I was told to display something which was wrong, but I was not aware. The technical expert told me it's displayed. I did. Now that party is filing a case against me for misrepresentation because I did it. But I was innocent. I did misrepresentation, but that was not intentional, not deliberate, not that impactful. When the intention comes and the effect becomes more, it becomes fraud. When it can be done, misrepresentation can be done innocently also. Can be just breaching my duty. What I'm supposed to do, I'm not doing. And because of that misrepresentation, it is misrepresentation. Intentionally doing with the intention to harm the person, to enter into the contract, that is fraud. Okay, so difference is intent to deceive. The first thing for fraud. Concealment of fact. You conceal the fact. You hide something and sell it off and makes the contract. Fraud. Promise. You promise something, don't do. Like you say that I will do, if you sign the contract, you don't do, or maybe under some influence. That is fraudulent act or omission. Anything. Act or omission means act doing something, omission not doing something. If so, act can be an offense and omission also can be offense. The example which I gave, the person who was near the pond, he was hired to save the person. He did not did. Did not did means it was not act, it was omission. Omission of his duty. So both can be. Misrepresentation says positive assertion, not sure if it is true. See, here intent, here uncertainty. The person was not sure whether this have this, I will buy. Yeah, I think it had. Misrepresentation. You are not sure, you are saying it has, or it may have. So the impact is less than fraud. Breach of duty. You are supposed to do your duty to enter into the contract. You did not do so. You made some shortcuts. Causing innocently, the third point, a contracting party to make a mistake. Innocently, you made one party to make a mistake who's going to be the part of the contract. So it is misrepresentation. Now, free consent should not be caused by a mistake. The fifth point is mistake. Mistake means, now we talked about coercion, we talked about undue influence, we talked about fraud, misrepresentation. These all should not be there in the contract. Then the contract is fair and valid. Now we say mistake. What is mistake? All those four were also mistakes.
During course of execution, something has happened which is not.
You are making a contract. You are not executing the contract.
Mistakes means whether means you know the things, but you missed the things.
Yeah, missed it.
Missed what?
Some
Here I
facts,
say
some facts.
fact or what? This is a Latin maxim.
Sentence.
Fact.
Wordings.
Fact. What else? Mistake is of two types in law. One is fact. You don't know the fact. What else? You don't know the law. All of us know the law. Office and meeting, anything happens, a common violation, DPK says, criminal act, jail, well. So is it,
Yeah.
he knows the law? Example.
I think
All of us don't know.
unawareness.
Even if you are aware also. Everybody is not supposed to be a lawyer, right? So There is a Latin maxim in front of you. Ignorantia facti excusat, ignorantia legis nihil excusat. It is a Latin maxim, which means ignorance of law is not excusable, but ignorance of fact is excusable. Other way. Ignorance of fact is an excuse. You can say in court of law, you are driving a car. You have not seen the traffic light. You hit a person. You cannot say, no, no. It is something you are subject to. You cannot say it's not my intention to do so, but you did. You have to pay the penalty, irrespective of your intention. Same way, when you say ignorance of fact, you prove in court of law that I was not aware about this. You cannot prove, say in the court, I don't know the law, that if I beat somebody or kill somebody, I'll be hanged. I don't know this. Will it be accepted? No. So ignorance of fact is excuse, but ignorance of law is not. This is that Latin maxim. Based on this thing is there.
So in the same scenario, we have to prove that we are right. So ignorance of fact, what it would be in this scenario?
You made a deal, you purchased the property, and that was a discrepant property. That was under legal dispute. You can prove I was not aware about it. You will assert your rights. If you buy a disputed property, you are not supposed to buy. Okay. Now that another party which is under the dispute, he comes and says it is my property.
Okay, sir. If in another case that Damodas and BB case, Damodas can say that, and I was not aware of this.
Wait. That was not this. That was this.
But he didn't know the law.
It's not an excuse. You cannot say. That is why I am trying to explain. You don't know you have to drive in the right side on the road.
I know.
You don't know if you murder somebody, you will be hanged.
No, sir. I will interrupt. Sorry.
Maybe
What
the
is-
fine tunings of law, you don't know, but basic law, it talks about the crux of the,
Yeah.
it's a maxim. Maxim comes with the people's use. It's not a theory. This is a maxim I told. Maxim comes with the usage. So it is based on the usage. It's a general thing.
He was not aware of this minor and the major thing.
How? He is supposed to know. That's a minor. That again, this is challengeable. How you will prove that you are not, you don't know? Tomorrow you say, I don't know how I have to wear clothes. I can go naked on the road. No, it's an example. You can see in law, you will see strange objections, principle-less observations. Tell me what I told wrong. Had somebody written and make an agreement with you that you will wear the clothes? I will not give 10th exams. I'm not aware about the law. Can you say that? The question is reasonableness. The principle of law is reasonableness. Whatever you argue, if it is reasonable, it will work.
Is this not, this is also,
If somebody, it's not related for the particular country. He may use, it may be that on that country may be the law, but this country is, wherever he is there, he's done a mistake, that country is having a different, that law is applicable. So whether he cannot able to check.
He was anticipated to know when he's going a country. It's a very good question. Very relevant question. You are visiting a country, you are anticipated to know. You bring the bottle of wine outside the airport. You see the magic. You cannot say. It is implied that you, whenever you are going, you have known and gone through the law of that country. They are not asking you to see the commercial law or see the contract law or see the company law of that country. General things. Then you will not allowed to go outside. Emergency landing on the airport only, right? So you will be in the airport. If you are going outside, it is implied that you must know the law of the country. You cannot say this. You drive on left side here, Saudi. They will allow you. In my country, it is there. I am not aware about your law. If you're not aware about the law, go out of the country. If you don't know about the law of the society, get out of the society. You are very much part of it. You are required to know the basic law. Another thing, wherever you go, you cannot deny the local territorial jurisdiction. When you go to a country, you are subject to the law of land of that country. Wherever you are. If you make any business activity, it will be governed with the law of, it may be governed with the law of other country, but that law should not contradict with this law. If that law, any terms of that law will contradict with the local law, it will prevail. That's why in this project, we signed the agreement with the jurisdiction of
UK.
UK, arbitration of UK. We are living in Saudi Arabia. Can we give the resort to the government of Saudi Arabia? We will not follow your law because our contract is governed with the UK law. No. Why?
Saudi Arabia law will prevail.
On, not all. Where there is a conflict, this will prevail. Where there is no conflict, that will prevail.
There is no conflict, it means it's the same, right?
Yeah. Wherever there is a conflict on any clause, this will prevail. Maybe something is not written.
Right.
Maybe in English law something is written, but here not written at all. Then by default that will happen.
Then
Okay.
what we have proposed, why we are proposing that in law? We should-
That is client's requirement because seeing his lenders and all. And how we ensure that? We have just signed it. No. What we did? Anybody? Had you ever heard of any document in our project called legal opinion? Just heard of?
Yes,
What was that legal opinion? A third party confirms. I, being a contractor, have to arrange a third party legal agency confirmation that the law of Saudi Arabia on these contracting points does not contradicts the law of UK. It is acceptable as per the law, an international legal agency. He will certify and I will put that report to client, then this agreement is accepted. Just like for signing, we will and then we will enjoy. No. A third party, a standalone different legal association which is recognized, he should say that the nature of job, the guidelines, the UK law is not in contradiction with your Saudi Arabia. Then we can proceed. Otherwise, people will make, okay, let's sit in India, make a contracts applicable for Singapore. That's it. No. Otherwise, it's void. If that legal validation is not there, agreement is over. Okay, so you cannot say that is the mistake of law, leave me. No. Mistake of fact you prove. In court also we prove mistake of fact only, right? We never prove mistake of law. If you try to prove mistake of law, court will say, hello, gentlemen, go to prison. What we prove? I did this, I murdered somebody. I did not murder, I did for self-defense. So what you are proving? You are proving fact. Any question?
yes.
Oh, tell me.
Going back to that case.
Which case? Not many cases that.
Damodar.
No, I don't know. Don't put that case. That case is straight
I
away.
will complicate it a bit.
Okay. But
Now-
again, wait. You don't know the fact of the case. How can you complicate it? It was not an example.
As per the story that you.
No, it was not an example. It was an actual case which happened. You cannot twist the facts. It happened. That person should have seen the deed and seen his age. It was in front of his eyes.
No, sir. What I'm saying that I will remove that age factor. I will come to sir, listen. So now one person came into the existence to whom the A party is selling the property. Now the B party, who is the seller, A1 is Damodar who gave the money.
Give the name only. Don't confuse.
Get the money.
Okay, he is getting the money.
Who B party is getting the money because he was the owner of the land.
Party is given the money.
No, B party has consumed the money.
Damodar Das gone with his papers.
Okay, sir, let's.
That I am the, wait.
That
I am the one on whose name it is that. Law property says that a minor can be given a property, but he is not authorized to transact. He cannot be a transferee, nothing. So it was on his name. He seen that. He did not see his date of birth. He did not seen by practicality that he is a minor. Because of the greed, he accepted and given him money, some amount that I will manage the way earlier Jamidars were doing. That was always there are facts which makes help to the law said. Facts decided. Document is in front of you. I'm not saying it's a mistake of law, or mistake of fact. Mistake of fact. Fact is in front of you.
Law, third party country law, applicable for the persons. Being all the contract applicable, or certain limits are there.
I said when there is a territorial transaction out of territory, if you go to any other country, you are subject to the law of land, the territorial jurisdiction. You cannot seek a resort. There are only some categories which are given that immunity, sovereign immunity, the diplomats. Another, there is a list of people. ministers and all of a particular category. They go as your company's, your country's representative. Those are given those exemptions. Otherwise, everybody, you and me come to here, we are subject to this law. Whatever we will do, if you do wrong, we will be penalized as per the law of this
Yeah,
country.
that's what I'm asking. If suppose some year later, we are taking on equipment from hiring agency. We are taking on equipment from hiring agency. There we cannot able to enforce that you have to follow the UK law.
That hiring agency is outside.
No, here only.
Okay.
That means they have to approve.
Wait. If that you are saying that the hiring agency is here, you are unable to get him approved on the English law. You can still go for local law. Why? You already have a legal opinion which says that there is no contradiction of local law with English law. You have that confirmation. Agree on local law.
There we need to put the third country law. It's not better. That I'm asking.
You can remove it, but if you remove it altogether, the problem with is that suppose there is an arbitration based on his equipment. You already agreed that arbitration will be in Saudi Arabia with him. With client, you agreed that it will be in Wales. Now, what is the problem? Arbitration seat where it will happen, it is in UK. Now, for this party's problem, you will take him with you. You want to go UK. He will say, why I will go UK? You agreed with Saudi Arabia. Come to Saudi Arabia. You will never be able to conclude the arbitration. Client, UK, and this guy, to maintain a symmetry with all the legal requirements. It is advised, don't change the applicable jurisdiction, don't change arbitration clause, don't change the seat of arbitration and rule of proceedings that I'll discuss. Because this is not one party affair. It may involve client, it may involve XYZ, lenders. So you have to do everything favoring them. Otherwise you will be in trouble. You will never be able to hold a party which is local and with you have signed the local law and local arbitration while your main agreement with the employer is UK arbitration. You have to align it. Otherwise, you will never be able to conclude arbitration. You will lose.
Suppose the same thing. Wanted to purchase on it. The same, there is a contract. Like there also I have mentioned that UK law will be followed, but that this the particular transaction and the particular procurement all this not related to the UK company. So in this case, why should we need to impose the UK law?
See, again, because he has nothing to do with UK, but his customer is having that. What for? I am not here to just purchase on my own. I have to give a service. What is the cause which you need to satisfy? Your main agreement with client. We are not purchasing for fun. We are purchasing to deliver to a person. And if whatever we do is not matching what he needs, who will be at default? You, not that party. So you have to keep EPC contract in your mind. Ultimate ambition of yours and the person who's supporting you is to fulfill that agreement. Not that supplier agreement we are going to like dying to fulfill. That is the help.
Here the case is it.
I know because you say because my main agreement says it should be as per UK law. Now you are international association. You find out, do you have anything which contradicts UK law? No, then sign it. They must have their legal person. They are running a company. They should have the legal person to validate
In
it.
this case, we have mixed companies. The contract is like federal to the UK company, UK law. So we have to follow the all.
As I said, you have to follow. See what L&T has to do with UK. We have nothing. We are nowhere in UK. We are signing the contract for UK law. The same result we can get to client. We have nothing to do with UK. We sign Indian law or Saudi law. But it is a requirement of client. The way we agree to UK law, they should agree to UK law. If they have to supply for this project to our end customer, who need for UK? Example, A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of bargaining. Though neither party was aware of the fact. Here, the mistake of law or mistake of fact? Sami, busy eating biscuit, huh?
Mistake of fact.
Great, very good. Mistake of fact. Fact is that the horse is dead. So it's not mistake of law. The agreement is void. Because you prove that it's a mistake of fact.
So in this case, suppose A has given some amount for this agreement, B has to return back.
Yes. When there is no
Return
agreement,
back by law.
when there is no agreement, there is no consideration. If you paid, you will get it. By default, he has to give you.
Like token amount when some people are.
Whatever he received, you have the receipt or you prove that he has taken, he has to give. No agreement, no
It will be
consideration.
by law. By
Yeah.
law, he has to give.
Law says consideration is necessarily essential. If consideration is not there,
Agreement is not there.
yeah, when you paid the consideration and there was an agreement, there was intention to agreement, he has to give it back. But you have to establish it. You cannot say in here, I gave it.
But we should pull
Yes.
some invoices or something that they have received them or given them.
Yes, yes, too. Lawful consideration, now essential of valid contract. We seen the other thing, that it should be free from coercion, mistakes, fraud, or this and that. Now the next is lawful consideration, lawful object. This both we have discussed in detail. What is lawful consideration, lawful object? Consideration or object is lawful. Now, I give you with examples that this is lawful, this is unlawful. What are the general rules? What is a lawful consideration or lawful object? So the X says that any consideration or object is lawful if it is free from 5 things. Anything which is forbidden by law. Indian law, if it says that you cannot transact in some shillings or something, some currency, and I'm making that transaction, it is unlawful. Because if it is prohibited by the law of the country. So then it is a unlawful consideration. Of such nature, if permitted, will defeat the provisions of law. Means which by itself is not prohibited, but if it allowed, may defeat the provisions of law. Allowing persons cross border, there may be terrorists. So that is there. It's just a vague example, but this is the situation. So something which does not apparently look illegal, but if it allowed, it can defeat the provisions of law. It does not say that if it allowed, it becomes illegal. If allowed, it will defeat the provisions of law. Fraudulent. Imply injury to person or property of others. So any consideration or object, if it have all these and one more is there, which is against the public policy, should not be immoral or against the public policy as regarded by a court. The question somebody asked, I told you can go naked outside. Immoral. Morality is not legally enforceable, but it can be a ground for rejecting the contract.
In fact, that. in the-
Otherwise, society will be totally immoral if there is no weightage of morality in the society.
And when this, you might be aware of this slit work. So is it any?
We are talking about contracts. Restrict your brain to contracts,
Civil manager.
not civil. I told in the starting. Okay, criminal, civil, I can give you example to just make the difference, but we are talking about contract. Contract will not be void. You cannot do something immoral while making a contract. You are making a contract with somebody, you slap him. Will he sign the contract? Just an example. So
Unless you
any
get some
consideration
good
of object, any consideration of object is lawful unless it satisfies any of them. If it satisfies any of them, it becomes unlawful. Forbidden by law, you cannot do. Such nature, if permitted, will defeat the provisions of law. Yes, you cannot do. Fraudulent, you cannot do. Imply injury to person or property of others. You are making a house, making a swimming pool, and it is spoiling the foundation of others' house adjacent to you. You are not allowed to do so. Immoral or against public policy as regarded by the court. This also you cannot do. Example, A promises to obtain for B an employment in the public services and B promises to pay 1,000 rupees to A. The agreement is void as the consideration for it is unlawful. Clear? Second, now on you. A promises B to drop a prosecution which he has instituted against B for robbery and B promises to restore the value of the things taken. Is it okay? Robbery is an offense? Okay, you help yourself and let me know what you understood from this. A promises B to drop a prosecution. You drop the prosecution, you drop the lawsuit, which he has instituted against B for robbery.
This kind of out of court settlement.
Yes.
Out of court settlement is legal. See the language.
Restore the value of the.
He has to take off, huh? Where is it?
Promises to drop a VC instituted and B promises to restore the value of things taken. Is it lawful?
This is lawful, not
Because robbery is
It's lawful.
Rajinama.
It's robbery, you say. Huh?
Robbery.
Ultimate for what for it is done. It is going to done in, it is being done to influence something which is crime. Totally unlawful. And the one which is not expressly declared void. If the government gives a rule that the contract under this category is void, you make the contract, you satisfy all others. But when the contract itself is prohibited by law, you cannot make it. Okay.